There are a number of things that I find particularly alarming whilst I've been working on this case on a pro bono basis or free of charge basis. Firstly, since I said as much that I was prepared to assist on this case pro bono in my first video, the sheer number of emails and phone calls, contacts that we've had to the firm from members of the public who have each a grievance with the police or a local authority or governmental department, and they've been treated extremely unfairly in many of the cases that I've read about, quite horrific cases, and the sheer difficulty that they've had in trying to get hold of somebody to discuss these things. Now, I can say that I've experienced this firsthand in trying, as a lawyer instructed in this case, to assist and to find something out. Now, I've spoken to a number of very lovely and very helpful people, each of whom have not really been in a position to assist me at all. I'm waiting for a call back from one of the officers in this video, which I'm yet to receive. I have sent out correspondence to them. I've also sent correspondence, very detailed correspondence, to the press office, and I'm awaiting something back from them as well. I've spent more hours than I can count looking into it, thinking about it, reviewing the video. I've had numerous conferences with the client in this case, which is a normal procedure to take things down. Obviously, that entails detailed notes and so on. But the sheer difficulty in actually getting to speak to anybody to talk some sense into this is very difficult and concerning. And I also find it quite alarming that the general way that this has been dealt with by way of the police update. Because as I discussed about this press update in my previous video, I don't believe they should have gone into so much detail. And I've received correspondence from officers with many decades of experience, either in this press office itself or in the police force, and some senior officers saying that they would not have handled it this way. Now, I don't want to jump to criticism too much, but I don't believe that this was the best way of handling it, and I do believe that there is another way forward. And thank you all so much for subscribing to my channels in support of me whilst doing this pro bono case. I really do appreciate that. I have 4 main channels here, as you can see, they're all growing. I'd love to get my main one to 1 million and grow the others, so thank you so much for doing that. I really do appreciate that. But one particularly alarming bit about this case was the point of entry. Now, each of us should feel sort of safe in our own home. We have a right to privacy under Article 8. And of course, if you are being arrested for an indictable offence, there are powers to enter to arrest you for said indictable offence. I'll come to those in just a minute. And also, if you've already been arrested, there is a power to enter your property because you've been arrested, to then carry out a search and seizure and so on. And there are various other grounds within the legislation, for example, saving life or limb, preventing serious damage to property, or such things like that. Now, with those in mind, I'll come back to those in a moment. But first of all, I'm going to play you a short snippet from this video. Now, there's a reason that the volume is taken out of part of this. I will explain what that is and why and what's being said. It's essentially names that are being used, which obviously are being kept private. My original comment about the video being snipped was because of privacy, and that is right. But allow me to show you this video. And there are a number of alarming aspects about this interaction. Now, whilst I can't play the whole video for you and I can't tell you every detail, I can tell you some specifics and about how the officers acted generally, because police officers should be held to the highest standards. But this particular bit here is about the entry to the property, which, as I've said before, was done without consent. And it's quite clear from the video. Take a listen to this.
So why is this? What evidence have you got that she's a suspect?
But that can be all discussed in an interview.
Yeah, and that's why we're saying we're happy to go to the station now.
Yeah, but you're not understanding what we're saying. We need to seize that phone now because to prevent this.
And so this is where I've lowered the volume and I've paused the video. But by this point in the interaction here, I can tell you, having made a transcript of the full video, which I can't show you, but there are at least, that I can count, 15 separate occasions where the police officers threaten some sort of escalation or threaten arrest or threaten a demand and a seizure of the phone, etc. There are at least 8 requests by the mother to have a solicitor. And there are at least 9 occasions where the mother said that she'd be prepared to attend a voluntary interview. And despite all of that, at the end of this, all of those interactions, the mother then felt so oppressed that she had no choice but to call her daughter to fetch the phone, which is why the volume has been lowered. Not just to change the narrative of the video, but it was, as I said, for reasons of privacy. But after all that, then have a look at how this entry takes place.
Just get the phone.
One of us needs to go with her in order to...
No, absolutely not.
What can we do to prevent destruction of evidence?
No, you're not allowed in here. I'm sorry.
Now, that last point there, it's muted by me because the officer was shouting the lady's name into her face and then physically pushed her way through. So you can quite clearly hear from that video that one of the officers said, one of us needs to go with her. The mother says, no, absolutely not. You are not allowed in here. So if this were to go to court for claims of unlawful entry, for trespass and so on, it would be for a court to determine whether or not, based on what you've just heard, and obviously any body-worn footage from the officers, whether or not that was a lawful entry. Now, I'm going to come on to a case in just a moment in the second half of the video about entry to a property that was deemed unlawful. Now, my last few videos and stories have highlighted how facts and events can get distorted and twisted, misinterpreted, or even misrepresented, depending on who's telling the story and what your perspective is. And so that is why I partner with a company on this channel called Ground News, because I use it to read different sides of a story, and I'd like to show you an example. So let's take a look at this headline here. It shows dozens arrested around the UK at protests to support the proscribed group Palestine Action. Now, depending on whether it's a left or right-leaning outlet, you might get a different headline and you might be told the story slightly differently. Ground News has a biased distribution on the right-hand side here, showing you who is covering the story, and you can see that 51% is central, and there's a left and a right-leaning split. Let's take the bias comparison provided by Ground News here to get an idea of the differences between the two sides. You can see that the left-leaning coverage focuses on civil liberties, free speech, portraying these arrests as heavy-handed repression, and focusing on terms like complicity in genocide. The right-leaning headlines, on the other hand, stress terms like banned and anti-Israel, deploying delegitimizing language underscoring the security threats justifying police action against this group. And then you can see how this is played out in the headlines to you, with headlines such as mass arrests at Palestine Action protest in London, the grannies getting arrested for Palestine Action, and the third one here, the government has lost the argument on Palestine Action. From right-leaning headlines, however, UK police arrest 66 at London protests supporting banned anti-Israel group. And again in multiple headlines, you can see that arrests have been made in relation to a banned Palestine Action group. And of course, there'll always be some stories that are not properly covered by the left or the right, and so Ground News has a blind spot feature which will show you those stories only covered mostly by the left or by the right, so you can get both sides of the story. And of course, as they're a partner to my channel, you get a great discount, which is 40% off the subscription if you use the link on screen and linked down below, ground.news/BBB, and you'll get the full picture because you'll be able to read both sides of the headlines. And believe me, it's really interesting to know the different sides and to get an idea of the bias breakdown, the ownership breakdown, and everything else that matters to you. So check out Ground News, ground.news/BBB for your 40% discount, and I think you'll love it. Because if I remind you, first of all, under the Police and Criminal Evidence Act, under Section 8, there is the power for a Justice of the Peace to authorise entry, otherwise known as a search warrant, to enter the premises. There is Section 17, which is the entry for the purposes of arrest. And then there is Section 18, which is entry and search after an arrest has been made. And then under subsection 2, constable may seize and retain anything for which he may search under subsection 1. And of course, this must be for an indictable offence. And also there is section 32, which is search upon arrest, and so on. However, so let's take a look at this case, because I think you'll find this quite interesting. So in this case, this is the case summary. The claimant here, who was the husband, referred to as F, he sought damages for trespass to the land, false imprisonment, and assault from the defendant chief constable. Obviously, as I mentioned, that's just against the police force. And the summary is as follows. The neighbour had called the police after being alerted to a disturbance at this guy's home. During a heated argument, F had squirted suntan lotion and thrown apples at his wife. But he then took an overdose of tablets. The police officer, R, attended the scene and spoke to F's wife. According to the officer, she looked dishevelled and upset, mentioned the overdose to him, and that the husband F had grabbed her by the arms and shaken her. The officer went round to the back of the house with the wife and saw the husband in the kitchen. Now here's a very technical and important point of law here. The officer then opened the back door and went in. So you'll find later that was a technical use of force because he opened the door. So it's a use of force in a technical sense to open the door and then go in. So the question obviously there is, was he invited in or did he have a power to enter? So when he got in there, the husband told him to get out. A struggle ensued between them and F was arrested and handcuffed. The chief constable, i.e. the police force, argued that the officer's entry to the home had been justified since it was properly inferred that he'd entered the home with the wife's consent, and alternatively that he'd entered the home to deal with a breach of the peace and to prevent harm. However, as mentioned, this man then brought a claim against the police for trespass to land, false imprisonment and assault arising out of this incident, saying that the police officer shouldn't have entered and shouldn't have arrested him, because the struggle ensued because he told him to get out, and the struggle ensued because he said the officer shouldn't have been there. Now, the judge here heard lengthy legal submissions about the questions of law relating to the entry by a police constable into a private family home, in the context that he attended to deal with, on the face of it, a domestic dispute between husband and wife. The entry itself was not in dispute, nor was it a dispute that the officer used a force in a technical sense of the word, in that he opened the door, and as defined in law, that is the use of force to open the door and enter the house. Eventually, and our applications to amend pleadings, etc., on the third day of trial, the defendant force then put forward 3 justifications for entry to the house, but the burden of proving the justification would be upon the police force. Now, in analysing this case, the judge here said, in relation to consent to enter the property, clearly, if the police officers were invited into the premises by an occupier who's been told them the reason for entry, then their enter will be lawful. And there's a case law for that. In the present case, as in this case that the judge is talking about here, not my case, but this case here, you understand, the judge said the officer was not invited into the property. He himself opened the door and went in, neither seeking permission nor explaining as to the reasons for wanting to enter. The judge said the police evidence at its highest amounted to no more than saying that no one had told him not to go in. So he assumed that the wife was consenting, and i.e. he assumed therefore that she was consenting because she didn't expressly forbid him to enter. The judge, however, said an assumption of consent on the part of the police officer in such circumstances cannot in law amount to implied license to enter a private dwelling. No reason for entry was given. In the judgment, the judge said there is, on the police officer's own evidence, no basis on which the jury could properly conclude in this case that he had consent from the occupier to enter the premises. After much legal discussion later, the judge then said it follows that as a matter of law, a police constable does not have the power to enter a private dwelling house in order merely to carry out an investigation as to whether there might or in the future be a further breach of the peace. The judge said, in my judgment, therefore, the decision in Unlawful applies in this case. He says the officer's entry was unlawful and the claimant was entitled to take reasonable steps to remove him from the premises. In other words, the police officer was on the premises unlawfully, and he said the claimant in this case had the grounds to take reasonable steps to remove him from the premises. The judge said, even if I'm wrong about that, I take the view in relation to the second issue arising under this head that the evidence advanced in support of this ground is not capable of justifying entry into the premises pursuant to the power contained in section 17. More legal discussion later, the judge said, in my judgment, therefore, there's no evidence upon which this jury could properly conclude that the police officer's entry to the premises was justified under section 17 of PACE. It follows from all the above, the judge said, I agree with the submissions of Mr. Williams on behalf of the claimant that the police officer's entry of the claimant's home in the circumstances of this case was unlawful. It therefore follows Mr. Thwaites accepted that the claimant was entitled to use reasonable force to resist the officer and eject him, and that no issue relating to liability remained to be determined by the jury. The judge did warn towards the end to say that the decision was based entirely on the particular facts of this case, and it would obviously not apply to cases where different circumstances exist requiring very different approach to be taken by attending officers. And so in short, in this case, the officer had entered the property using technical force by opening the door, assuming that he had consent, or on another ground that it was necessary because he apprehended a breach of the peace or to investigate the overdose. The judge didn't accept any of these and found that the officer was unlawfully on the premises and therefore liable to damages for trespass, false imprisonment, and assault because the officer had technically forced his way into the property and that scuffle ensued. So I've seen all sorts of comments online in relation to my case where people have said, the police are allowed in to do certain things. There are powers of entry, there are powers of arrest, there are powers of search, and there are powers of seizure. They have to be executed properly. And if not, the police do need to be held to account. Now, as I've said to the police, and I've said to you on my videos here, I'm very transparent. I don't want to be bashing the police over the head. They have a difficult job. It is difficult to get all of these things right, but with the greatest respect, these officers absolutely must fully understand these powers when exercising them, else they may be liable to trespass, false imprisonment, conversion of property if they've handled property that hasn't been lawfully seized, and so on. And not to mention breach of Article 8 rights and all sorts of other things. So again, let me know your thoughts in comments in the box below. I'm sorry that I can't go into greater detail in this case because it is my case. Whilst it is not live in the sense that she's not been arrested, she's not been charged, but I can comment on it nonetheless within the realms and the bounds of my professional obligations. So I hope you found that useful and interesting. Please do subscribe to the channels. That really does help my channel grow. And I am enjoying helping on this pro bono case, and I may well do many more of them. So thank you for watching. I'll see you next time.